I'd like to thank the speakers for some very rich presentations, and I'd just like to draw attention to some key points that I think were made and that make the whole question of transitional justice interesting, but point to the complexity of it. I think the point that justice is integral to peace that Nick was making, and that it's not necessarily doesn't necessarily conflict with peace building, is crucial, while at the same time pointing out this issue that domestic justice is more effective probably than internationally driven justice, while at the same time internationally driven justice can support domestic justice processes. And the point that Nick made about, despite all the difficulties at the political level of how these unfold, we shouldn't forget the importance of the deterrent effect of justice in terms of more long-term processes of stabilization and preventing conflict in the future. At the domestic level, and looking at the South African experience, I think Janet's story of the truth-telling process and the impact of disclosure, with all the caveats and the fact that it was incomplete in terms of satisfying that political process of the transitional justice, nonetheless seems to have helped the reconciliation process, but perhaps more important in terms of the long-term, I don't know if you call it state building, but democratization, has been the transformational impact of the experience of the constituent process itself, and which has brought into the discussion more integrally this question of not only thinking about retributive justice, but preventative justice, and thinking about entitlements beyond conflict and injustice in the past. And that connects to Richard's point that maybe we need to also look at the non-retributive character of elements of African society, and look also at the complexities of justice, that justice, while the retributive aspect of it is important, there are multiple layers of justice that can play out as part of how transitional justice processes develop. For example, truth-telling has a different quality to criminal justice, and reparations equally bring in different dimensions. And these multiple approaches to justice and multiple levels of where this can unfold, for instance, they can unfold at the local level, at the community level, and maybe part of the picture that we need to be building, and the understanding that there are no easy solutions to how these issues unfold. And finally, and I think how Richard ended it, was very important in that respect, pointing to the fact that context, as we all know, is crucial in the understanding the histories, the political and social histories of these countries is absolutely vital in ensuring that they inform the way in which these justice issues can be worked out politically, whether at the domestic or international level. So those are some of the issues that I think we can discuss further, and I'd like to open the floor to questions from the audience.
Peter Tesh, I'm media advisor with the Indonesian Embassy, but I have also an interest in Africa. I have a question for Richard and Nick. I would like to ask Nick about the agreement between Timor-Leste and the Republic of Indonesia, which has their own reconciliation and truth element, and which some of the NGOs like yourself have criticized. Why? Because I would like to know more why you do it, because I feel that if the Republic of Indonesia and the Timor-Leste can come to agreement on justice, there's no point for ICC to interfere. On Richard, I would ask, you mentioned Ireland, and I find it very interesting, because Irish peace process is the one kind of thing which is hardly mentioned, and even this part of this country. A peace agreement was concluded, which in fact declared amnesty for all crimes before a certain date. Weapons were decommissioned, so they could not be reproduced for criminal investigations later. So is that not a model? If the UK government can agree to it, why can't other, is this model not used in other countries?
I think we'll take a couple of more questions in this first round.
My question is for Nick, and it's about Kenya and what's going on right now there. And I'm thinking because the conflict was like a year and a half ago, and already there's a truth commission and all this pressure from the ICC and the international legal community. Can this then put so much pressure on the country as to take it back to conflict? Is there a time period when a country should be allowed to consolidate its peace before all this pressure is brought to bear, because it has the potential to take it back to conflict even before the next general election?
Thank you. I have a question for Janet Love. You mentioned the division on the economic and social level in South Africa. That's still a big issue. As far as I know, the TRC only tackled gross human rights violations, and not what you could call ordinary violence or everyday racism. There was an expression of the highly discriminative system in itself. Do you think that the TRC should have put more emphasis on these kinds of violence in order to tackle the issue of division that is still that's still actual today?
I'll take those questions for now. And for the next round, could I also remind you just to say your name and where you're from as well? And maybe you can start.
I'm happy to pick up on the. I'm happy to pick up on the Irish one. I mean, since 1968, when the conflict began, the idea of the British government and the rest of the world was to bring the moderates together. So all the time there were sort of left-wing unionists and more conservative nationalists, and they were continually trying to bring them together and to form an administration which would exclude the gunmen, to keep the bad guys out, the extremists, to marginalise the extremists. And the only one that worked was the exact opposite. When Martin McGuinness and Ian Paisley sat down together, and the representatives of the IRA and the hardline unionists actually formed the government, that was what was brought peace. And it was extraordinary. And I think that may be a lesson for elsewhere as well. The Afghanistan comes to mind, I'm afraid.
The question on Timor-Leste and Indonesia, I mean, these are difficult issues. To what extent, if you have a deal between leaderships, can you say that represents the will of the people and therefore ensures that all of these issues are being dealt with? And to take examples that I know slightly better, Afghanistan. Okay, you have warlords in government. You have amnesty passed by the parliament, dominated by warlords. Is that representative of the state of the popular will in Afghanistan? Will it address the underlying issues? But I don't want to take a righteous approach to this. I mean, maybe the argument is, when one looks at Africa, there are very good examples where a refusal to address justice in a retributive way, such as Mozambique and so on, has a result that most would say is a positive result. Whether it would be any more positive if you dealt with justice in a more systematic way is an open question. I mean, justice advocates will argue that South Africa didn't deal with justice in a fully comprehensive way. There weren't trials for those even that didn't appear and give evidence before the TRC. Senior leaders on the nationalist side weren't prosecuted. That was part of the grand bargain. So, if the grand bargain wasn't fulfilled, but, as Richard said, it's a remarkable transition. But I think it's too easy just to say because the leaderships do a deal, then nothing more needs to be done. The leaderships are often the representatives of the abusers or the perpetrators. Sierra Leone, Angola, I can give you a whole list, Afghanistan. So it's more complex than that. And what I'm trying to get at is to try and look at what are we trying to achieve and what are the mechanisms. That's hugely complex to address these issues. The Kenya, again, it's hard to know. Why I like Kenya as an example is a very good, empowered commission, Kenyan-led commission, said, look, there's a culture of impunity in Kenya, failure to address it since independence has created a cycle whereby we know there will be violence next time round. BBC story 2 days ago, widespread purchasing of AK-47s and guns in Kenya. The fear that the violence next time won't be spears and burning of churches, but mass violence with sophisticated weapons. Who knows? But the people that are looking at this and looking at these cycles of violence are saying that that's the case. So, and the recommendation of the Commission itself was use these mechanisms. We know that if we leave it to our political leaders, we are not going to have action because it's their power that is being threatened. I mean, this is the value perhaps of the external actor. You can't wish it away, you can't deal it away. And I don't know where Kenyans kind of sit on this. I mean, certainly the popular press is broadly and if not hugely supportive of international intervention. It was Kofi Annan that led the process that also kind of recommended international engagement in all of this. So, I mean, I think Kenya is an easier example for justice advocates than a lot of these other places.
With regard to the TRC and it only dealing with gross violations, that's not in fact the case. I mean, it did deal with gross violations, and that was what preoccupied a lot of its time. But the mandate of the TRC, in fact, was very, very wide. And so the fact that certain issues that led to the level of disparity and the level of inequity that exists, the fact that those things were not fully unpacked, or even in some cases unpacked at all, is an indication that the process did have some limits, and it's why the current government of South Africa has entertained discussions with the people who are taking up the tort claims in the US around sanction busting that played a direct role in reinforcing the military regime that perpetrated some of the violence. And in the same vein, I think I need to just correct something that Peter has said, is that there was no part of the bargain that was to give people automatic amnesty. That is absolutely not the case. The TRC process was to enable people to come and give the truth. It was to give victims the opportunity to express their views, and then the TRC had the sole right on whether to or not to allow for amnesty to be granted. And it was only on the basis of those two conditions having been fully satisfied. Recently, one of the cases that the LRC has brought before the courts was to strike down an attempt to amend the prosecution policy to enable the prosecution to, in fact, the national prosecutor to provide amnesty to individuals because it was regarded as not fulfilling all of the criteria of the TRC process. So just to clarify that. Just as a final comment, I just wanted to say to Richard, I'm not sure that the British government ever learns. They tried this issue of not bringing together the so-called extremists and putting together all those so-called nice and tame middle-of-the-road types. I mean, they've tried it all over the world. Muzorewa is only just one sort of regional example. I have no doubt they won't learn. I don't know whether that's pessimism. Thank you. We'll take a second round of questions.
Hi, Marta Foresti from ODI. First a reflection and then a question. A reflection is, I was glad to hear stories and reflections from France and the UK and Ireland. I'm from Italy, so I am, at a day like today, I'm very clearly reminded of the force that constitutional process can have to address a form of abuse of power. Now, it may well be that it may well be that politicians are not going to make anything of it because they're not good enough. But it was actually really refreshing to know that there is a constitution that says that certain laws can be abuse of power. So my question is for Richard, but I would also like to hear Janet's comments on it. You pointed to the need for new forms of democracy in a lot of African countries that do something about the winners-take-all phenomena. What has does the rule of law have a place or a role to contribute to that? Again, I know it's difficult to speak in generally, but do you think that the rule of law and the justice system can actually do something in practice to prevent that winner's take all, or is it just a matter of political settlement and political forms? Thanks.
Thank you.
My name is Aurélien Toby. I'm working for International Alert in the training department. It's more of a request for clarification, actually. When it comes to justice, a lot of the words we use are perpetrators and victims. But it seems to me that in the nature of current conflicts, actually, this distinction doesn't really reflect the nature of current conflicts. I mean, if we look at the reintegration of ex-combatants, I mean, when justice comes into these reintegration issues, it's highly problematic, and the question is really who to bring to justice and for what purpose, really. And I really appreciate the example from South Africa, where actually it's more social justice or more just state that's actually needed more than retributive justice. Thank
you. Donald Curtis, ex-academic, once an anthropologist, and that sort of thing. An observation first. When I was in a village in Botswana, sitting in the court, listening to discussions, which sometimes were judicial discussions, I was reminded that the Tswana principle is not that a law should be simply enforced. It wasn't a matter just of retributive justice as against reconciliation, but whether in fact both can be achieved. And this took the form that once there had been discussion and agreement as to what had actually happened, the accused, or the representative of the accused, was then given the right to sum up, assuming that he would, and it was nearly always a he, would take the position that the court had arrived at, and therefore, if necessary, sum up against the person who's representing, which is a fairly strong way of making sure that there's a reconciliation process. I then think a little bit about the Sudan. In the Sudan, one which I haven't heard much discussed, it used to be the case that the role of the state was to broker relationships between different groups of people. And this was I saw this in Darfur a number of years ago. The state commission, the commissioner representing the government, would sit with his 2 or 3 soldiers with their weapons, with armed groups in front of him, until they found some way of making a reconciliation. And the government taxation system actually was adjusted so that if there was a blood feud and a fine, that could be levied by through the government and paid to the party that was offending. That seems to have disappeared. But in these cases, the interesting thing is that there is the role of the center, the state, or the justice system, is actually more about presiding than being a superior power. And finally, coming to South Africa, this is my question. The constitutional process and the interim government process at local government as well as national government level actually had those different parties sitting obliged to continuously talk to each other. Once you had a final constitutional settlement, then they could, one party won all, and they ceased talking to each other, perhaps. So could there have been a different outcome?
2 final questions at the end.
I'm Marie-Claire Farey from the Women International League for Peace and Freedom, and I'm also from the Congo. I'm very concerned when I heard Nick and Richard talk, because it seems to me that you have a lot of prescription and an understanding of what is needed for African, and it looks as if most of the way peace versus justice or transitional justice is being described for African countries is Western patronizing and very colonialistic way of looking at how things can be solved in Africa. I mean, when I say this, is because I don't think before Western society or civilization came to Africa, these people knew how to resolve their conflict. And I don't think that what has been happening at the moment really suits most of our culture. Because as we look, we hear about non-retributive justice. It suits many African countries than retributive justice. And we cannot look at peace and, justice without human security first. And when you talk about putting new democracy for African country, I want to ask you, what you call democracy really? What are you calling democracy? And I was very shocked when Richard is talking about Kenya and thinking that there will be new form of violence. It's like you're prescribing already for African what you're seeing. And even for Richard, when you talk about there's no identity between people in Nigeria, there's no identity, Congolese people don't feel. This is really bad because it seems as if there is a form of way where you are looking at us in Africa, where we don't look at ourselves as being different. Indeed, we came together as tribes and all this with, after the Berlin Conference. But at the end of the day, I think African people want to develop human development first and then start looking at how they can build their country. But there is a lot of interference right now that need to be acknowledged and addressed, and also international justice need to be addressed. Where we look today in Rwanda, for example, retributive justice in terms of the tribunal in Tanzania, where you haven't really had an inter-Rwandan dialogue to address the problem in Rwanda. And in Congo, they favor peace at no cost, meaning that violence has been legitimized. We have rebels who are leading the country. So today, we really want to know what the international community is doing about African people themselves being on the driving seat of their own justice and how they're seeing reconciliation. Thank you.
Thank you.
My question, I would like to echo Richard's sentiment, which is that what happened in South Africa is indeed a miracle, because the situation just over 10 years had all the components of a perfect storm. Racism, poverty, all sorts of issues. So 10 years later, South Africa is off the news. That is a miracle. I would like to put my question to Janet. How is South Africa dealing with the golden elephant that is in the room, but no one talks about it, which is land? There's still land injustice, and how is it dealing with it in order to prevent what happened in Zimbabwe from happening? And just another question for the rest of the panel is that this morning President Obama was given a Nobel Peace Prize. Do you think that was premature, or is that going to help peace and justice, and also help in understanding transnational justice in fragile states? Thank you.
Thank you. There are a lot of people that want to ask questions, but I think we are going to have to draw the discussion to an end, so I'm going to ask our panelists to answer some of those questions and sum up some of the main points that they'd like to bring in at this stage. Nick, perhaps you can.
Let me just draw out a couple of points. First, the point about perpetrators and victims in National Alert. Yes and no. I think it's more of a continuum. You can identify perpetrators, you can identify victims, and of course there can be a middle ground where it's very difficult to identify. Let's talk about Lord's Resistance Army. I'm quite happy to identify Coney as a perpetrator. Yet one of the indictees, one of the commanders indicted by the ICC is Daniel Ongwen. Now, Ongwen was abducted himself. He was an abductee and grown up in the LRA. To what extent is he responsible? To what extent is he a victim? That's a very difficult issue. I can't give you a reference, but there was a very interesting paper that was put out a little while ago by Erin Lynch, I think it was, that looked at the history and trying to come to grips with an understanding of this. Yeah, but let's pretend there aren't people we can identify as perpetrators, or at least put them before a process that we think is accountable and have that process. And the same kind of comment I'd make on the comment about Sudan. I'm not answering your question, but you talked about, is it restorative justice or retributive justice? Well, in an ideal framework, it's the whole range of mechanisms. I mean, you look at something like the ICC, with over 100 countries signed up to it. It's been going for 5 years. It has 4 prosecutions underway. I mean, about 8 arrest warrants issued. It's never going to deal with the whole mass of justice issues. And in a country like the Congo, where the ICC is active, or Sudan, it's other mechanisms that are going to fill the void. And then let me just kind of come to the comment about commenting from a Western perspective on this. That's the perspective I bring. I hope that it's not being imposed on anyone. I'm trying to set out the basis on which one can approach these issues. I mean, when one looks at the Congo as one of the most horrendous human security problems in the world today, with an excess mortality rate of 30,000 people a month, of course human security should be at the front and centre of that, but the argument is, how does one achieve that? Does one achieve it? One has a coalition government of national unity with perpetrators as part of the government. That's the Congolese government structure in place. It's the Congolese government that invited in the ICC with various motives at play, but has asked this international mechanism to go in. Will that solve the Congo's problems? Absolutely not. The solution to the Congo's problems are going to be a domestic-driven process, and I don't know how that will play out, and it will only work if it addresses these horrendous human security issues. So, yeah. Thank you.
Maybe just in picking up on the issue of the perpetrators, victims, the fact of looking at the role of peace and justice within the African context. I just want to say, and in our constitution, we have a clause in the constitution which indicates that traditional authority, traditional law, is part of our law. Now, if you can imagine, traditional law is not documented in the way in which civil ordinances and so on are documented. So what is traditional law? And the problem is that many of the traditional practices that existed under apartheid were very much part of the legacy of the British colonial rule, which, as we know, has used traditional structures over time to be the agents of colonial domination, and has bastardized those structures, and it did it quite extensively within the South African context. So that you have a situation where traditional authority is understood through the eyes of very carefully documented academic doctrines from ex-colonial countries, whatever the good intention is of the writers, to the extent that that intention might have existed. And there are huge problems with that. Now, our Constitution says that traditional law is part of our legal system to the extent that traditional law is not in conflict with our Bill of Rights. Now, what that means, and we've taken it as an organization on a few occasions and are still doing that because we see that as being a huge part of developing the law to our Constitutional Court. Our Constitutional Court has ruled that the only way you can achieve a kind of justice system that integrates, in fact, what is good about traditional systems, what is the legacy of Africa, and what is appropriate to Africa, is if you recognize traditional authority and traditional law as living law, just as any other law. It's not in accordance with some book somewhere, but it's in accordance with practice and the evolution of practice, which is evolving all the time. And I think the examples that have been given about Sudan, about Botswana, etc., really do reinforce that. So to me, there's a huge volume of information that exists right across the continent. There was recently a very interesting meeting that took place in Kenya, which tries to look at the systems that African society has through the extended family structure of taking over foster care and guardianship for orphaned children. Now, that's a hugely important thing in the context of HIV and AIDS, and it's really something that has to be looked at also in the interests and the security of the child and what we've learnt about those risks and dangers. So I think there's a whole body of knowledge that really needs to be unpacked. Last point, South African miracle. I'm very proud of what our country has achieved. Very emotional about it, and I love it when people call it a miracle. I just want to say that a miracle kind of suggests to me that it's something that came from the heavens, okay? And really, this came from real slog. This came from real good leadership inside the country and outside the country. And the problems are huge. We've still got to deal with them. And I just wish that the fact that it was in people's minds a miracle would not cause it to disappear from your media 10 years afterwards. Because what we're doing now is really the guts of transition. And that's what I think we should have everybody, you know, to be part of, the mutual learning experience. Thanks.
Thank you. I'll start with the rule of law. And yes, Africa's a very legalistic place. I mean, there's a lot of both traditional, if you like, village law being carried out, where people can argue their case, and then obviously at an what do we call it, a formal institutional level. But I'll just tell you one story there from Congo. I interviewed a judge there, and he said, well, there are 3 types of judges now in Kinshasa. The first one gives an absolutely impartial judgment. And they are quite rare, because my salary is worth less than $10 a month. The second one, he will go round all the litigants, and he will find the highest bidder, and he will award the case to them. And he said there are many of them. And then there is the third type, and he said this is the category I'm in, where I try and give a fair judgment, but then I go to the winner and I say, help me. You won, now I need to feed my children. Now, when you've got a legal system like that, I think, you know, I just thought, well, what would I do? It's quite tough in those sort of situations. But what I would say is there is the international national law. Now, what elements of traditional law could you bring into that which would be more appropriate for local conditions? And I think of the one that comes to mind is, it's not particularly typical of Africa, but it's because the Somalis are different, they're unique, but the bit of Somali that works, the Somaliland, nearly went back to war a couple of weeks ago, and they were coming up to the election. And it was the traditional leaders, the Gurti, which finally ruled, and they said to the political parties, sort it out, or we will sort it out for you. And they still have that authority to do that. And I thought that was a really remarkable moment when the traditional rulers were able to step in and save the situation. And then you have places like Rwanda with Gakacha, and there's a big debate whether this is a wonderful African solution to a problem that the legal system couldn't sort out because there are so many people to be tried, and this is a local solution to it, or is it just a cynical manipulation of tradition by a government to persecute its enemies? I think the jury's still out on that one. And somebody mentioned land, and yes, which is a cause of many, many wars in Africa, both over the areas where there were multiple uses between farmers and pastoralists, and just disputes like in Kenya, where land which was seized by the whites in colonial times, then handed to the new incoming government of Kenyatta, who then gave it to his friends, and of course it wasn't his friends were all Kikuyu, and this was in Kalenjin or Luo territory, and that was half the problem of the thing that exploded last year. And yes, land is a very serious issue, and I don't know many African governments that really want to tackle it because it's just too hot to handle. But I would say this is that the outsiders keep saying, well, just give title deeds, title deeds, title deeds. And it is not just simple, straightforward Western-style title deeds will be very damaging for Africa. Well, they've been tried they've been disempowered women because the men automatically take it for themselves. So the women lose, and of course women do most work on land. And secondly, it's where you've had a traditional holding, the chief who holds it in for everybody then takes it for himself and then sells it on to someone else, and the whole people gets thrown off their land. So I just wouldn't go for that simple title deed solution to it. I think again, let's hear it. Where Africa, tell us what you take power. Become master of your own ship and say, this is the way we used to do it. This is the best solution for us now. And if the World Bank or whoever else comes along and says, well, we're not happy with this, say, no, this is the way we want to do it. I hope we'll see more of that in coming years.
Thank you. I'd like to, before I thank our speakers for leading this very rich discussion, I'd just like to briefly remind you of the next session that we'll be having on this, which is on shaky foundations, political settlements, peace agreements, and the road to stability on the 20th of October. So you're all very welcome to come to that, and it will be building on many of the discussions we've had today and previous sessions. And I'd now like to thank our speakers for what I thought was a very rich and inspiring debate.